to Google and just Google the word technology transfer and look for some pictures and images. That is one of the first pictures and images which is popping up. It was used by WIPO, I think, in year 2010 for one of their, let's say, seminars about technology transfer. And these pictures somehow also put it really good and straight. What is technology transfer about? So, of course, you see on the left side the technology. So it is something technological, of course, has something to do with all technological innovations and so on. And on the right side, you find a lot about communication ways, people, also transfer. Then you have a lot of, let's say, relations between these two parts, communication ways, which goes from one to other one and goes back and goes forth. All that is somehow or tries somehow to illustrate what technology transfer is about. So let's actually take a minute and think about it. How would you define technology transfer? Is your idea of technology transfer somehow, let's say, can be seen in that picture, yes or not? I was told that most of you would work as a technology transfer officer. So I would say actually you are even much more qualified than I am in that domain. Um, and so I wanted to, at least, even if it's not in a present form, uh, ask you, think about it. I put that image for about, let's say, 20, 30 seconds in front of you without saying anything. Let you think about how would you define technology transfer. So I have by now you had at least time to think about what would technology transfer mean for you. So what can I do is, of course, to look it up. As for example, I can look it up in a dictionary. If I look in some dictionary, you will find some, let's say, uh, sort of definitions like the flow between two or more participants of technological information and its successful integration into production by the recipient. So there are, of course, these two uh, notions, technology and transfer, somehow translated in transfer like the flow, and of course technology like technological information. So here the at least this definition sees that the technology is more than just technology by itself, but it involves all sort of technological information. Then there is a part which is quite important, that is the successful integration. So a technology transfer involves somehow this successful integration into production by the recipient. So it is not that actually you just transmit your knowledge and you let it go, and if the other one cannot do it, sorry for you, it was your fault. I told you how to do it, you were not able to do what I told you. You need, in fact, as somebody who is in the technology transfer, also sure that is somehow successfully integrated and it brought at least into production. So there is actually also another definition you can find, which is from WIPO. WIPO is actually World Intellectual Property Organization from the year 2010, and it says a series of processes for sharing ideas, knowledge, technology, and skills with another individual or institution, leading to the acquisition by the other of such ideas, knowledge, technology, and skills. So for them, it is, let's say, an ensemble of processes for sharing ideas, not only ideas, but also knowledge and technology skills. And that shall lead to a sort of acquisition by the other one. So what is put in advance is also the commercial part of technology transfer, that there is an acquisition. So you need actually to pay for something, and somebody has to pay for that. Okay, that is the idea of WIPO. Is it correct? Let's see. Then UNEP, that is actually also another UN organization about developing countries, and so says that the capacity to assimilate, implement, and develop a technology which ultimately leads to its consolidation in the developing country. So, first of all, it is a capacity now. It's not just a flow, and it's not just sharing ideas. And then, of course, again, implementing, assimilating, developing technology, and then consolidating in developing country. So that is maybe another level of technology transfer. It is somehow a definition of technology transfer on a higher level than we might think when we are thinking of technology transfer in the universities and so on. So are they wrong, or all of them are correct? How can it be that all of them are somehow correct, or maybe some of them are wrong? That question might be answered if we think about what is technology transfer. So first of all, you can think of two types of technology transfer: the so-called vertical technology transfer and horizontal technology transfer. So the vertical technology transfer is something which happens normally inside a corporation. So for example, you take the technology from research and development and you bring it to the production. All that happens inside a corporation, inside that unity. So it goes in a vertical way, and these technology transfer shall come from inside and it remains inside. Then you might have actually horizontal technology transfer. That is technology transfer that you have between several institutions and also across countries. So this time we are not inside a unity, but it is between different unities. And these different unities can be also spread all over the world. So one can be in one country, the other one in another country, and that is what maybe UNEP thought of as they gave their, uh, let's say, definition. So in fact, both of or all three ideas we have heard of could be correct regarding if you are thinking of sort of vertical or horizontal technology transfer. And the horizontal technology transfer can go beyond every other aspect. So we see that technology transfer has really multiple facets. So you cannot just remind us by saying it is like that, it is like that. And as we have seen in the three definitions before, many other types might be also taken to consideration. So some of them are, for example, migrating basic research into marketable inventions. That can happen inside a company. So that is a vertical technology transfer, as most of the companies are doing. There is actually a research and development unit, and these is developing the idea, and then once it is developed, you have to bring it to production. So it is not so straightforward. You need actually adaptations and so on, assimilation. You have to teach your colleagues in the production, and they have to find their own way to make it productible. Then you have, for example, technology transfer in investing in adaptive R&D, including foreign direct investment. So, in fact, that is when you are searching for somebody who might finance your research and development in order to bring it to, let's say, to production. Then it involves a lot of course, intellectual property rights. So that is one of the main questions of technology transfer, and why I am involved in those type of, let's say, transactions. So uh, intellectual property rights are at the heart of technology transfer. So one has to say, without them, it would quite be quite difficult to have a common base in order to have the right answer to the question. So intellectual property rights is one of the main part in any cases, in transversal, in actually vertical, and in horizontal technology transfer. In all that cases, the intellectual property rights are at the heart of it. Then it involves a lot of contractual arrangements, as for the case of joint ventures, licensing partners, and all that can be done only if you have the acceptable legal frame, and you have the possibility to act within that legal frame. Then it shall help to capacity building, knowledge and information sharing. That is one of the main aspects of the technology transfer. We will see that it is even actually mentioned in some international treaties and so on. So that this is one of the most important points. This capacity building, this knowledge and information sharing, that is also quite important. Then, of course, we do all that not for nothing. It is done in order to establish a market, in order to make some product that can be sold. So, establishing the market is also can be also a part of it. So, we have seen one of the definitions was about how to integrate it successfully into production. And then it goes now beyond that. It is not only that, but also the idea of that sort of, let's say, successful integration is, of course, to establish a market. So go back to our country, to my country where I'm working at, that is in Switzerland, and let's see how do we see the technology transfer. In the case of Switzerland, we think that technology transfer includes not only the transfer of know-how procedures good, but also the one from organizational and managerial procedures. So it is, of course, a transfer of the complete system. So uh, you can also have the transfer of components, whatever it is needed for that time. So you can have actually a complete transfer of the whole system, but also one or several part of as the components. You can actually just have the transfer of know-how or the transfer of goods, uh, equipment, services, or you have the possibility of the transfer of the complete system. In any case, one shall know that in fact soft skills and policy frame are really crucial for these components of the technology transfer. So the legal frame where you are working at shall be done, of course, also the trade frame shall be done in a certain way that it is beneficial to a technology transfer. So if the legal frame, for example, is done in a manner that it is somehow even, let's say, not prohibited maybe, but at least becomes more difficult, uh, such sort of transfers, then, of course, if it becomes illegal, for example, to share the knowledge and so on, then you have a real problem in such a system. Of course, such a system does not exist, but there are systems which are more or less flexible, more or less, more or less adaptive to conditions of, let's say, technology transfer. So the next question we have asked ourselves is actually, why do we need maybe a technology transfer? Why are the main reasons which is make it actually somehow necessary to have the technology transfer? So one thing is actually we are not alone in the world, and we know by now that nowadays uh, things are much more complicated than before. So even, let's say, our daily used devices which all we all possess and which we all have, like a smartphone, for example, are real and really complex systems. So it is not that easy for just one company to put everything together. We need, in fact, cooperation, and technology transfer is part of the cooperation agreement. So a cooperation agreement can only have its full and good result if the technology transfer is done properly within that cooperation agreement. We are actually so far that they invented a new word. We are now talking about co-petition, which is actually competition and cooperation at the same time. So we are talking no more from cooperation and competition. We're talking about co-petition, because cooperation is nowadays, we have to say, it is inevitable. You need cooperation in most of the cases. Then, of course, one way of avoidance or resolution of legal disputes is also technology transfer. So once you have some infringement cases and so on, uh, actually the easiest part would be to try to take a license, and part of the license, actually, technology transfer is also a question of licensing and so on. So in fact, legal disputes are very costly and so on. So in those cases, if you want to avoid them, technology transfer might be a very good tool. Then, of course, for merger and acquisition transactions, that is inevitable when two companies will merge, or one company will make some acquisition on the other one. For those type of transactions, part of that is, of course, the technology transfer. So you have to involve the technology of that, let's say, actually, the company you want to take over, or to want to merge together, and that might also bring a lot of synergies between these two companies, and that is the idea behind merger and acquisition. Then uh, exploiting of patents, or IP rights in general, but patents in particular. So you might have actually a patent, and as we know, patents are not bound to a technological field. Your patent might have also some possibilities of development in other technological fields where you don't have maybe the know-how and so on, and technology transfer and licensing in that case would give you the possibility also to have new markets, new, let's say, access to other uh, parts of technology. Then of course, just for the need of transfer of technology. The name of technology transfer is also implying that. So this time we are transferring the technology maybe from one country to another one. So how actually to help between countries, how to let's say give other countries the opportunity to use the same technology. We are at least interested that the other countries in the world are so prosperous like any other country. So that is also part of the prosperity, to have access to the same condition of technology. Then, of course, patent license exchange agreements. That is actually when we are talking about cross licensing. Both parties have some patents which is interesting for the other one. So you are coming to the cross licensing. In that case, of course, you have to make also in both sides a technology transfer. Also, in that cases, in the cross licensing cases. Or, for example, you think of a joint venture foundation from the parent company. So you have some joint venture foundations where actually come together from two parent companies and they make actually this joint venture. So you need actually a technology transfer from each parent company to the joint venture. And then, of course, inside this joint venture, you need also to assure the flow of information so it actually the synergies can develop and you can profit it. Then the same goes for actually distribution projects and also for the production contracts. All that cases are special cases where technology transfer is important and why technology transfer is needed. So as we said, there are different, let's say, contexts which are involved, which different, let's say, facets which are involved in technology transfer. There is, for example, the facet of organizational context of technology. That is, for example, about the structural design, the information flows, legal form, and so on. You have, of course, also the institutional context of technology transfer. It is about policies, shared values, incentive systems, and so on. And you have also the individual context of technology transfer. As you know, that actually, when you have a technology transfer, you have also people. And these people having their own, let's say, background, their own professional ethics, personal goals, attitudes, skills, knowledge, experience. And then you have, in fact, also different type of actors in that let's say technology transfer. So all that different context and all that different facets are collaborating together, of course, among each other, uh, with, let's say, the result, which is for all of them the same, is the effectiveness of a technology transfer. So let's say, in fact, the effectiveness of the technology transfer depends on all that different contexts, the organizational, institutional, and individual context. So you can have actually the best legal frame from the institutional part. You have actually a very good organizational, let's say, prosper organizational actually context. However, you have the persons who are not willing to do that. So that cannot lead to an effective, let's say, technology transfer. So all these together shall work and cooperate so at the end you will achieve the effectiveness which is needed. Of course, this I'm sorry, this effectiveness is in fact somehow granted legally or binding legally by some licensing contracts and some other business formation. However, uh, that is not a guarantee of success. The guarantee of success is that all that shall collaborate together in order to have the right aspects. So now let us see actually what happens in a very special case. First of all, we have to say that the question of technological, let's say, um, technology and knowledge and so on is a question which is of highest importance for the humanity as itself. So for those of you who are not, let's say, familiar with TRIPS, that is actually, TRIPS is an international agreement. Uh, that is the most important international agreement on IP matters. TRIP agreement is actually signed by a lot of countries, almost all of the countries, and the even trips has of course some article, and the whole starts to remind us even why IP came to the world, why we started the IP. I mean, nowadays maybe IP is also used in other manner, but one of the main questions of IP was to make some incentives for people to do the innovation. And on the other side, and that was very important, that these innovation is also transmitted, and that is part of the dissemination of the knowledge. Because we are human beings, and the human beings are in the situation in the we are nowadays. Uh, we think we are at least actually quite well established and developed and so on, thanks to the knowledge transfer. Without the knowledge transfer, the human being would do the same mistakes every time from the beginning. So we cannot make an evolution in that case. It is not just a question of intelligence. There are, let's say, nowadays we are sure about that, that there are even animals in the world uh, which are far more intelligent than human beings. The only real difference between us and them is that we teach our knowledge to our children, for example. So these teaching, this dissemination of knowledge is that what made us human beings. And that is what shall not be neglected when we are talking about, let's say, IP. A lot of actually international instruments of UN, a lot of actually, let's say, international uh, even agreements have some provision about technology transfer. And in TRIPS, for example, that is actually the objectives of Article 7, which says the protection and enforcement of intellectual property rights should contribute to the promotion of technological innovation and to the transfer and dissemination of technology. So it is actually in the, let's say, objectives of these, let's say, agreement, the dissemination of transfer of technology. So you see actually how important it is in that very important international treaty. Further, in the same treaty, you will find also some obligations for governments. So, for example, not only that it shall be part of, let's say, what you do for yourself, every country who accepted these, let's say, treaty, it is said in the objectives, you have to use IP rights in order to help dissemination of technology. But also, it is trans-country, so across different countries. The Article 66, line 2, it says developed country members shall provide incentives to enterprises and institutions in their own territories for the purpose of promoting and encouraging technology transfer to least developed country members. So it is actually even somehow written that the so-called developed countries are in obligation to do something uh, to let's say facilitate these technology transfer to other countries. So all that has been said now, how that happens, for example, in a country like Switzerland. So what we said up until now is what is asked from us by this international treaty. We have signed that treaty from the beginning, so we are obliged to apply the different articles and provisions of that international treaty. So, what is Switzerland, for example, doing in order to create the possibility of technology transfer and the dissemination of knowledge inside the country? And also, what are the incentives to the enterprises and institutions in Switzerland for promoting technology transfer to other, for example, less developed countries? So, first of all, uh, you see there is a number of different institutions that are involved in technology transfer in Switzerland. So, more than 20 institutions from all different horizons. So you have actually, of course, the federal institutions like SECO. Also, what we are doing is somehow thanks SECO. Sorry, also my institution where I'm working at, IPI, we are involved on a federal level to that technology transfer activities. Then you have even in Switzerland a commission, a federal commission, which is in charge of that. So the Federal Commission for Technology and Innovation is called InnoSwiss. That is the commission who is in charge of technology transfer on the confederation level. So they are having a lot of different projects by their own and also collaborations. And the collaboration are going beyond just public, let's say, actors. They are also having some collaborations with private sector to disseminate the knowledge and also to facilitate technology transfer. Then, in like in your country, I'm sure there are actually a lot of technology transfer centers of universities and technical college. They are all under sort of the same, let's say, hub, which is called Unitectra. You have other technology transfer associations, for example, Swiss Technology Transfer Association, called Swiss. Then you have actually Swiss Parks. Uh, a lot of actually more or less private actors in that system. And for those of you who know a little bit about the political system in Switzerland, and also for those who don't know, this political system in Switzerland is on several levels. So the highest level is actually is about the confederation. So there's actually a federal system, but most of the power is on the level of cantons. So the country of Switzerland has about 26 cantons, which is sort of comparable, if you want, with the states in the United States. Of course, much more smaller. They're really small entities from the, let's say, from the area, but they have almost the same power. So most of the things are decided at the cantons level, and these cantons level, in fact, you have also technology transfer or technology transfer actually offices in the cantons level. So you have actually the university one, you have actually the let's say the technical university technology transfer system, and you have the canton technology transfer system. Then you have the ones which are in technology transfer or they're acting technology transfer on a private basis. And you have also the sort of center of technological excellences, which are sort of also public-private entities. Then you have, for example, the Campus Biotech Geneva, which includes all biotech-related, let's say, innovations in the west part of Switzerland, or for example, CSTM, which is actually is the center of microtechnical and electronic, and they are dealing with innovation in that field. So even actually different centers which are somehow specialized in different parts of technology. So, in fact, if you are more into the nanotechnology and so on, you have to go to that center. And if you are more of biotech, so there is actually another institution which is in charge of your innovations and so on. Then a lot of actually public-private partnerships where also we are involved. So there is a let's say private actor which is offering some also technology transfer activities together with our help from the public sector, and also in that case normally also InnoSwiss, which is involved in those projects. So it is not only a question of public, let's say, decision to do that. It is done also on the private basis, and also as a collaboration between private and public. Then, uh, on the level of actually doing some incentives or giving some incentives in order to make the technology transfer to the least developed countries. So one thing is, I'll give you just one example, is actually this example of the Swiss export risk insurance. The Swiss Export Risk Insurance, or SERV, is actually an institution which is under public law, and it is owned by the Swiss government, by the Swiss Confederation. Uh, their duty is actually to provide a system of export risk. They insure goods and services which are destined to export, where, for example, private assurances do not cover enough or do not cover at all. So maybe actually, that most of the least developed countries are not seen as the countries where, for example, the let's say the transfers are quite secure and so on. So normally you might have a lot of difficulties in order to make sure that if something happens, uh, at least your good and your services insured somewhere. And you cannot find in many cases for many countries, especially countries which are in war and so on and so forth, an insurance, a private insurance, who is going to make an insurance for your let's say goods. What here happens is, even in that cases, SERV is your partner. You go to them, they would insure to that. That is again these exporters insurance doing that in order to make some incentive and facilitate the export. And of course, so you contribute to a constant technology transfer by these types of intervention. That is actually one of the examples how these incentives are done from the government side, for example, inside Switzerland. So let's go now to an example which is maybe also familiar to you. It is actually one of the highest ranked technology institutions in the world, ETH Zurich. That is actually the Swiss Institute of Technology in Zurich. They have their own technology transfer office. The ETH transfer is in charge of the technology transfer in Zurich. They have the mission to support the ETH community, that is all the searchers, all the PhD students, all also professors who are doing research and development in all questions regarding to research contracts with industry, in inventions, patenting, and licensing. So they are also supporting young entrepreneurs in the early stage of founding their own companies. So normally what happens is, so in a normal way, once inside a laboratory, there is an let's say a patentable idea is popping up. Uh, these the laboratory and actually the responsibles, also the student who is actually in charge of that, are somehow informed that they have to contact ETH technology transfer for that. So the ETH technology transfer is doing his work on one side, uh, make sure that that is, for example, patentable by letting some patent searches done. For that patent searches, we are at the IPI, we are providing some novelty searches for almost nothing, so that actually the searchers are coming to us. We call that assisted patent searches, because that is a patent search where an expert in patent searches, together with the person who is search who actually with the searcher who is in charge of that or the scientist who is in charge of that invention, together they are looking through all the possibilities of search, of patent search. So we are doing exactly what I taught you in the very first part of the modules, a patent search, in a of course in a professional way, together. And at the end of the day, a report will be established, and that report will determine if the idea is new and inventive. And be, regarding to what these report contains, the technology transfer office in ETH or any other, most of them are doing nowadays like that, they will decide about how to proceed further. So if they are thinking that there is a potential of, uh, let's say, patenting that idea, they proceed by an application. And the idea is actually ETH is taking in charge the rest of it, which is actually writing the patent, or let's write the patent, application of the patent at the PCT level, and then they go up until the 13 months, the date at which they have to decide in which countries they want to keep the patent. During the time, of course, from the side of the laboratory and also the scientist, either they decide to make a startup, so they are the young entrepreneurs, if you want, and they take over by a license fee, for example, these patent from the ETH, or they decide not to do it themselves. Then you have to try to find an external, let's say, from someone from industry who's interested in that patent, and the licensing contract and so on will be done between, let's say, a technology, ETH technology transfer on behalf of ETH and the industry partner. So that is a licensing, and these licensing is in fact quite beneficial also for ETH Zurich, because that brings also money for them, and these money will be actually reinvested in the whole system of, uh, let's say, research and development of the ETH. So now, once you have actually these the whole system, the idea is, of course, not only to invest in patenting, but in the long term, of course, to make some remuneration, to make some money out of it. So ETH transfer has a lot of licensing contracts now, which brings them, of course, the money. And these money they earn, it is not the money which is earned for private purposes. It is the money they, uh, again, they can actually invest in their research and development, and keep the high research level of ETH all along this time. I gave you actually an example of that. There are lots of that examples. That is actually an example the licensing opportunity for a tunable porosity of bacterial cellulose foam for medical and food applications. So that was actually something which was developed in one of the ETH laboratories, and it was patented, and this patent was licensed then to an industrial partner who actually is now using that patent. But also, using that patent is not just you give them the patent and license, they have to do it. You have to transfer also the technology, which means actually you have to transfer the know-how how to do it, and so on and so forth. So all that is part of the work of ETH transfer. So all that is actually not possible without an adapted legal framework. So, in order to achieve all that what we said, you need, in any case, a legal framework to do it. Otherwise, it would not be possible to put into force something that would work together. Actually, these interplay of different actors and so on needs a legal framework. You need it because in any case you have to come back to that in one day. We know all that if everything goes good, there is no problem. So everybody would do the thing he want to do, and but it is always something which can go wrong, and in that moment you need it. So at latest, when some problem pops up, you need that legal framework. So let's take a look at the legal framework in Switzerland again, just as an example how it was done, and why it might be actually quite let's say quite quite adapted to that what we want to have, namely the technology transfer. So the Swiss constitution has some articles, of course, about the search and academic. So the Article 20 is talking about actually academic freedom. So it is granted research and teaching freedom. So that is actually the basis. Otherwise, you cannot go on and ask universities to do the search or to do the research work, and without any legal, let's say, backup for that. Then, of course, what the Confederation has to do. So, the Confederation has the mission to promote scientific research and innovation. It is even written in the Article 64, and of course its support conditional, in particular on quality assurance and coordination being granted. So it is not just let's say give out situation. You make some condition. The condition is in fact on the quality assurance and coordination being granted. So also from the side of the universities, from the side of the research institutes, it is it is asked that they have to do their homework, assure the quality of the research, and of course the coordination is done in a perfect way. Of course, and it may establish, take over, or run research institute. That is actually also what the Constitution gives as the right. So let's say, first of all, that the Confederation has the right to conduct and run a research institute. That is the case, at least for two of them. But they can also, if they think that is necessary, take over it, and they are also allowed to establish new ones. So again, that means that the government is involved at all levels into research and innovation. So then again, some articles about the higher education institutions, and there you can find, in fact, which are these two institutions which I talked about just a minutes ago. These are actually the two in Lausanne and in Zurich. So Swiss Federal Institute of Technology Lausanne, and you have actually Swiss Federal Institute of Technology Zurich. And the management of that is the mission of Confederation. Uh, of course, the government is also allowed to manage additional universities or higher education institutions if it is necessary. I told you before the system in Switzerland is some sort of, it's actually a real confederation. So in fact you have on the one side the cantonal power, and normally all universities are under, let's say, cantonal authorities. So the canton authority decide about having or not a university. And if they have a university, they are normally in charge of that university, except, in fact, for these both federal institutes. All other universities, for example, University of Bern is belonging to the Canton Bern. The University of Geneva is belonging to the Canton of Geneva. And even in Lausanne, for example, or in Zurich, you have the University of Zurich, which is under the authority of Canton Zurich. You have the University of Lausanne, which is under the authority of the Canton Vaud. And then you have both federal institutes in those two cities, and those federal institutes are, in fact, under the management of the Confederation. So even by these separation, you will see that in the same constitution, it is written that it shall even support the cantonal universities and make financial contributions to higher education institution that it recognizes. So that does not mean that if they are not managing the other universities, the government has the power not to support them. So actually, higher education is part of their mission, and even it is the responsibility of the canton to make the university. The confederation has the mission and has actually the duty to help them financially, at least. It is also, of course, accepted for other institutions if they are recognized on a federal level. Then, now that was actually about the constitution, higher education, and so on and so forth. So that is one part of the legal frame. It's just actually very general. Talk about what shall be done by the government, what is the implication of the government, and at which level. For example, for some universities at the level of financial aspects, at the other, even in management aspects, they are involved or not. But still, it is just one part of it. The research is, of course, one part of it. The other part, when we are talking about the contractual situation, is, of course, what is done on the legal frame for the contracts. So, if you look through, let's say, different legal, let's say, text in Switzerland, uh, there is the code of obligations that normally uh, shall be responsible for the all the contractual, let's say, aspects, and there is no special law for technology transfer. So through all that obligation code, you can make a search, and there is nothing about technology transfer or a contract regarding to technology transfer. So it is not a codified contract, and so it is not specifically regulated by obligation code. So what does it mean? Does it mean that actually everything can be accepted? Uh, In terms of form, yes. There is no formal, let's say, characteristics of that contract which is asked by the law directly. So formally, you can, as let's say, as a lawyer, you can write the contract whatever you want formally. However, uh, there are some conditions, and these conditions are generally accepted for almost all contracts. We are talking about the contracts a bit more in the next, let's say, module, when we are talking about licenses and other possibilities of contracts. Uh, but just to say it now for this special case, first of all, the content shall not be impossible or shall not be illegal. So other than that, you have in fact the freedom of contract. So whatever it is written in the contract, as long as both parties accepted it, is also accepted by law. There are, as I told you, these two aspects. I will come to that again a bit later in order to show you what are the examples for that. So that you will see that, okay, even if this freedom is given, there are some mechanism to protect, uh, especially to protect the, let's say, the party which is in a weaker situation. So these mechanisms are somehow said in these two words, impossibility or illegality, but we can come to that. So, uh, so this says that principally there is the freedom of contract. That means actually you are free to conclude or not to conclude a contract. Nobody shall be obliged to conclude a contract. Okay, you are free to choose your partner of contract again. You are free even to choose the type of contract. Is it actually for some time and afterwards it ends, or it is actually forever? What does it mean forever? You have actually, you need a clause in that contract to say actually how long does it last and so on. But that is actually type of contract is the question you shall answer yourselves. So then you have or both parties are allowed to establish the content they want in that contract. So they can write the terms of the contracts in mutual, let's say, acceptance. They are actually formally free. Well, there are some legal provisions that still remain reserved, but at least formally they are free of form. And of course, there is a freedom to terminate or alter a contract, given that the contract has regulated that. Otherwise, it would be a question that shall be answered by a judge. So, uh, the requirement of a valid contract is that there is real and common intention behind it. So, that is, in fact, now we are going in the direction to see that the weaker party might accept, because these parties quite under pressure, everything, and then the other party can say, yeah, we have the freedom of contract and you signed it. So that is where, in fact, these protection mechanisms come. It says it shall be a real and common intention. So the intention shall be real, not obliged, because the other one says actually either you do it or I won't give you, for example, any work to do so that actually you can die because you're completely dependent from me. Okay, so that can happen. You have actually these situations that a very big company has more or less actually the monopoly on certain things. And then if you are somehow working as another company together with these bigger company, and you are somehow delivering what they need, and you are actually delivering only one, let's say, because there is a monopoly, then that is you're delivering only this one actor. So he has all the cards in the hand in order to ask whatever he wants. Okay, so either you will give me what I want, and that we do it per contract, or you won't have any work anymore. So you can see where you bring your money. So it shall be a real intention and a common intention. Then there shall be a consent. That means actually there shall be the intention to bind themselves. Again, that would exclude any obligation or any obligational situation where at least one of the parties is not really in a situation to choose. So he has to do it, otherwise, no chance of survival. So, and again, the exclusion part says that the contract is not valid if it is impossible, if it is illegal or immoral. These are actually more or less very rare cases, or if the binding effect is too burdensome for one of the parties. So exactly what I told you. So if you are in such a situation that the contract is, of course, signed, but it is a one-sided contract and you had to do it, otherwise you could not survive, that is not a valid contract. So you see, you have almost all types of freedoms except of, let's say, hijacking. So it is somehow like that. You are hijacking the other party because you are in a powerful situation, and that is where, in fact, the judge and the law is on your side to help you in that. Then it shall also be invalidated if it did not respect the required form. So if there is a formal, let's say, there is a a formal, at least a formal requirement from the law, and you did not do it, then it is actually invalidated. We have seen in the case of actually technology transfer, there is no formal requirement, so this part would not apply in that case, except for some. So, and the party is not bound by the contract in the case of error, fraud, and duress. And that is again coming back to what I told you. When you are talking about duress, you are talking about a situation where one party is under hard situation, and it cannot defend himself due to circumstances. So we have to say that actually these cases have been seen. So that is not something that cannot happen. Of course, it can happen. So especially in the world of business, uh, it happens very often. So, and the judges are not happy with that situation. So if you are in that situation where the other party obliged you to do something, you can show that. It is not very difficult to show that. Then that is why the judges would very rapidly react on that, because there is a legal frame which clearly says that that is not acceptable. So now I'm talking a little bit, just a little bit about the rights of licensor and licensee, the typical obligations and so on. Uh, But I have to say that again, these part might be repeated a little bit later in the second module. Um, so I'm just going very rapidly over them. So you have actually obligations from the part of licensor, so that to tolerate use of subject of the license by the licensee. So if the licensee wants to use it, you cannot, as licensor, say no. Of course, you can. Again, it's a question of contract, the license contract. If it is contractually accepted that the licensor see in fact is allowed as a loan to use it, then okay, maybe actually the licensor might not be uh, the one who can use it. So once you do actually license contract, it is implicitly accepted that the other party pays for using it. So as a licensor, you cannot say no, you cannot use it, even if you pay for that. So that is quite logical. Then they provide the usage on the subject of the license or preservation of the legal situation. So the licensor has the obligation to preserve the licensee from a legal situation. Then he has a liability regarding third-party claims normally. If it is so, if there is a claim from third party that that can affect the license, that is actually the duty of licensor to react on that, and they provide the right to grant sub-licenses. Again, it is normally a question of contract. So if it is in the contract, somehow mentioned that the licensor don't want that there are some sub-license, that the licensee licenses on his side, it can actually be accepted if it is written in that contract. So the license contract shall be clearly somehow clear about that point as well. The licensee is obliged, of course, to pay the license fees. Otherwise, it is no use of that. Then again, the second part, the omission of acts that can risk the IP right, it shall not be overinterpreted, because, for example, if you overinterpret these clause, you would think that a licensee is not allowed to challenge the validity of the IP right. Uh, for example, you are the licensee of actually a patent, and that would exclude you from making a challenge on that patent. So I have to say that actually I would see that in another way. I would see that that most of the times it is not correct. What you that means actually as a licensee, you have still the right to challenge the validity of the IP right. However, what you cannot do is, for example, I don't know, hindering a licensor to pay the let's say the prolongation fees, the annual fees. So something that actually would kill the patent because of some administrational problem. That is, of course, this is not allowed. So or for example, it is contractually accepted that the licensee pays, for example, the annual fee, and licensee says, actually, you know what, I don't pay the license the annual fee, so the patent dies, and once the patent dies, I have not to pay for that. It is not the right way to do. But you cannot interpret that in that case that actually you are no more allowed to challenge the validity of the patent. So there are even, at least in European, maybe not in Switzerland, but in European, let's say, judgments, we had cases where it was granted that even the licensee can challenge the validity of patents. So maybe the patent was not new or not inventive, and didn't want that. And then this obligation of use, again, I would say that is something that as a licensor, you have to take care of it and put it there. I will come to that a bit later, why it is so important to have that clause in a license, let's say, agreement. But for the time being, just say that actually that is something, even if somehow in Switzerland, more or less it is accepted that is part of the license contract, this obligation, it is better to have it actually as a clause. It does not change anything. Then you have actually you have to create an enabling technology transfer environment. So in this part, I would rather give you some hints what can be done on, let's say, the governmental part to help this situation. Uh, the first thing we have to see and we have to agree on is that mostly these are multinational companies, and actually even big companies and chains, and also these global innovation networks that are the driving force behind innovation and international technology transfer. So uh, of course, these international technology transfer can only happen if there is a big company, let's say a multinational company behind it. Otherwise, I mean, the interests are maybe not big enough to do that. So you need these economical force and interest in order to have that type of technology transfer. So what the government can do is to create some environment where that can happen, where that type of technology transfer is doable and it is realizable without high hurdles. So uh, one thing is, of course, generally said, to create some incentives and interest of private sector. So as I told you before, that what in Switzerland is done in that aspect is even to create some sort of PPP, private public partnerships. So that actually the private sector is working on certain projects together with the public sector. And that is actually a sort of incentive. So you try actually to put in force that types of collaboration in order to create the incentive which is needed for private sector to invest on these type of technology transfer. Uh, Contractual freedom is actually a good step because it gives the necessary let's say freedom to both parties uh, to define their needs in terms of their contracts. So if you have a very rigid and decided contractual form from the beginning, and why you cannot decide about all possibilities beforehand, then one day you will have the problem if it is accepted and if it is actually these let's say very let's say solid and very let's say not flexible framework is enforced. So the idea of contractual freedom is to give some flexible or some flexibility to both parties to do and to act as it is beneficial for both of them. The only thing a government or the let's say juridical system has to do is to survey that it is done in a good form so that nobody actually accepted something against his consent. Transparency is maybe actually one of the most important ones. So you need transparency in your intellectual property system, an intellectual property system which actually gives the let's say the efficiency and enforceability which is necessary for that. The enforcement of intellectual property right is a very important part of the whole system. If you have the best, let's say, intellectual property laws in your country, but the enforceability is not correct, then you will have later or sooner a problem because people would know it is no use of having a patent and having the right on that patent when I cannot enforce my rights. So having a patent is only something, or having an IP right is something valuable, and the whole value of IP right is based on the enforceability. Without this enforceability, you don't have any value on that IP. So uh, the whole system, the whole juridical system shall work together, not only by, let's say, having good laws, having good and transparent laws, but also by having an efficient and understandable, transparent enforceability system. Otherwise, other ways that would not work. Other points to that, for example, of course, you shall invest in infrastructure to support sustainable market creation. So, without investment, sorry, no gain. So, no pain, no gain. And where to invest better than some infrastructure to support actually a market that has a chance to survive. Um, of course, tax regimes. So it is always a question about actually, of course, the governments need those taxes. On the other side, you need people to work to give you that taxes. So uh, let's say a transparent and competitive tax regime would help you even in gathering taxes because people who are working people who are actually making transactions, they can pay their taxes. Otherwise, it would be difficult to gather taxes. So just actually by having high taxes, the problem is not solved. Of course, just by lowering the taxes, the problem is not solved. It is not a question of having no taxes. The question is actually how to manage transparently and also in a manner that the tax regime is competitive and other companies would like to establish some let's say entities in that country. Then of course facilitating the knowledge and information sharing. So you have to assure free access to information as much as possible. That would also be done automatically for the case of patents, for example, as we saw in the patent search module. You have seen the access to 120 million documents out there without any without any restriction, and that is actually partly there. It is just maybe it's good to make these knowledge somehow disseminated so that everybody knows that there is these free access on information nowadays thanks to internet. Then we have seen actually the case in Switzerland with risk insurance for companies. So if they, in order to help them also to export in other countries and to establish their market in those countries. Uh, then promoting vertical technology transfer to support innovation. It means actually even not a horizontal form of technology transfer, but also inside an entity you have to promote, try to promote it to support innovation. And of course, not to forget that not everybody has exactly the same needs. So different sectors, different needs, and they shall be treated in different ways.